I'm an attorney with Liberty Counsel. Liberty Counsel supports Amendment 1 to Senate Bill 1236. We believe that 1236, as amended, is defensible and is constitutional.
Mr. Mast, even the people up here who are not hard of hearing are having a hard time hearing you.
Testing 1, 2, 3.
There you and speak right into it like
Okay.
this. All right.
So we believe that 1236, as amended, is constitutional and defensible. I agree with the final speaker yesterday, Mr. Bopp, that the life issue is a very serious issue. I'm also grateful to him and others in the pro-life movement who have litigated these cases and done the heavy lifting over many, many years, whose work places this committee in the state of Tennessee in the position that it is today. No? Yes? Can you hear me okay?
Better, but better.
I don't know how.
You are a soft-spoken gentleman.
Okay. He mentioned the NAACP and its long, slow slog of setting up the cases that eventually teed up Brown versus Board of Education and the other major civil rights cases. And we believe that, like the NAACP, the work of Mr. Bopp and others have set the stage for the High Court to revisit and reconsider Roe in light of new arguments that have never been addressed. You've heard from Professor McLeod how the Ninth Amendment presents unique arguments that the court has not addressed. You've heard from Mr. Kellum how the viability test is arbitrary, that medical science has made clear what was unknown at the time of Roe. The ground for Roe's abortion jurisprudence has eroded. You've heard from Mr. Fowler regarding signals to the committee and to us in the pro-life movement, and Gonzalez, particularly Justice Ginsburg's dissent, as well as how the 8th and 6th Circuits have picked up that language. You'll hear today how there's not a clear majority vote to reverse Roe and how the court must affirm it again based on the doctrine of stare decisis. I will testify today about whether the doctrine is a bar to reconsideration of Roe and Casey. I submit that it is not. And even under the current set of factors the court considers on whether to follow precedent, Roe should go down under this approach set forth in Amendment 1. I'd also recommend to your attention the Library of Congress Congressional Research Service, which has provided an excellent memo, which I can provide to the members of the committee. At least 3 cases decided this term, authored by Justice Thomas, Alito, and Chief Justice Roberts, signal a return to the idea that the Constitution itself, not what other judges have said about it, is controlling. In constitutional law, like other aspects of the law, words have objective meanings and are capable of being understood, consistent with the writer's intent. Or as Justice Thomas said, underlying the American legal system is the key premise that words, including written laws, are capable of objective, ascertainable meaning. And as Mr. Bopp pointed out, the novelty of the Ninth Amendment argument and lack of unconstitutional accretions that have been built up on the others makes that approach compelling, one that the current court, potentially with at least one more Trump appointee, is likely to take up. Stare decisis is the judicial doctrine by which courts follow the principles, rules, or standards of prior decisions or decisions of higher courts when deciding a case with similar facts. The purpose of this doctrine is to serve the rule of law. Follows that in unusual circumstances, when fidelity to any particular precedent does more damage to the rule of law than to advance it, we must be more willing to depart from that precedent. That's Chief Justice Roberts in Citizens United. The doctrine promotes the even-handed, predictable, and consistent development of legal principles, fosters reliance on judicial decisions, contributes to the actual and perceived integrity of the judicial process. On May 13th, 2019, the Supreme Court overturned 40-year-old precedent in Franchise Tax Board of California versus Hyatt that was authored by Thomas. He wrote, "Stare decisis does not compel continued adherence to erroneous precedent." Justice Breyer dissented, arguing that overturning well-reasoned decisions undermines the stability in the law and can only cause one to wonder what cases the court will overrule next. That opinion was joined by Roberts, Alito, Gorsuch, and Kavanaugh. Justice Brandeis said that the rule of stare decisis is not inflexible. Whether it shall be followed or departed from is a question entirely within the discretion of the court. It's usually the wise policy, but in most matters, it's more important that the applicable rule of law be settled rather than it be settled right. Justice Alito said in 2019, June 17th, in Gamble versus U.S., it's also important to be right. And it's important to be right when it comes to the lives of the unborn. So the factors of stare decisis as applied to Roe. Is Roe settled? Was it wrongly decided or well-reasoned? Is it still workable? Has the decision been eroded by factual changes? Has it been eroded by legal changes? And does it create substantial reliance interests the court should respect. How do these factors counsel treatment of Roe? Roe is not settled precedent. Age alone doesn't make it settled. Roe is 46 years old. The court has overruled much older decisions. Brown versus Board of Education overruled Plessy versus Ferguson after 58 years. And if age made Plessy a settled decision, then I wouldn't have been able to have dinner with Ambassador Keyes at the Nashville Woolworth last night. The court has overruled numerous other cases, 75 years old, 96 years old, 41 years old. Abood versus Detroit Board of Education, overruled by Janus, regarding compulsory payment of union dues. Is that settled precedent? Not when it violates the Constitution. It's been inconsistently applied. The court has disavowed fundamental rights status for abortion, disavowed strict scrutiny. It's adopted an undue burden test. It's created an undue burden and substantial obstacle test. It's gone through numerous permutations, and it's been subjected to a significant amount of criticism. Does Roe meet the standard of well-reasoned or rightly decided? No. It lacked an evidentiary record. It was not well considered. It was decided by a 3-judge federal district court existing at the time without any trial or evidentiary record on abortion, its risks, or implications. It was directly appealed to the Supreme Court without intermediate appellate review. There has been a similar treatment with the Second Amendment and U.S. versus Miller, which was ultimately overruled 69 years later by Heller versus D.C. Lack of evidentiary record, nothing tested by adversarial process, and everything in Roe was like that. There's no historical foundation for the right to abortion, and that is the beauty of the Ninth Amendment approach. The Ninth Amendment states the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Where was this contemporary list and authoritative treatment of other rights retained by the people to be found? In the common law, which was ignored or misconstrued by Roe. Blackstone was the foremost author or expositor of the common law at the time of the founding. And the common law was an issue in Nick versus Township of Scott, another June 2019 case in which Nick questions whether the text of the Takings Clause of the Fifth Amendment controlled private property shall not be taken for public use without just compensation, or a 34-year-old Supreme Court decision that was reading into the Fifth Amendment. And in Nick, the court overruled that previous precedent. Chief Justice Roberts said that we've identified these factors that I've discussed here. All of these factors counsel in favor of overruling Williamson County. Quote, Williamson County was not just wrong, its reasoning was exceptionally ill-founded and conflicted with much of our jurisprudence. Its key conclusion ignored many prior decisions, just like Roe, holding that a property owner acquires a Fifth Amendment right to compensation at the time of taking. The decision has come in for, quote, repeated criticism over the years from justices of this court and many respected commentators. Chief Justice Roberts concluded, fidelity to the Takings Clause and our cases construing it requires overruling Williamson and restoring claims to the full-fledged constitutional status the framers envisioned when they included that clause. Much could be said about the inclusion of the Ninth Amendment and how it has not been treated as a full-fledged member as well. Roe has also proven to be unworkable. Workability is a traditional ground for overruling it, or a lack of workability, that is. And rules in a prior decision may ultimately prove to be intolerable simply and defy practical workability. In other instances, it's been found, cases have been found unworkable because it is too difficult for lower courts to apply them consistently. Roe has been undermined by factual changes. Its assumptions have changed considerably. Biological and technical developments have reinforced the medical conclusions of the 1800s and the common law that the life of an individual human being begins at conception. There have been numerous legal changes since Roe, including the of women's rights. We have Title VII, we have the Pregnancy Discrimination Act, FMLA, and numerous others. And the international community has not followed Roe. The U.S. is one of only 7 nations that allows abortion after 20 weeks. So the conclusion, the poor reasoning of Roe is its lack of an evidentiary record, its lack of a historical foundation, the faulty medical assumptions, its lack of precedential foundation, its viability rule, Casey's discarding of that rule and replacement with other, and the unworkable nature of these combined rationales, and significant changes in fact, including full understandings of when life begins, ultrasound technology, surgical expertise, and other facts, all lead to the conclusion that Roe must fall. It will fall if the court applies its own doctrine of stare decisis fairly, The court needs a vehicle. This amendment, complete with recitals, Liberty Counsel believes is a good vehicle for the court to reconsider Roe and Casey. Roe was an aberration. Overruling it would not require overruling 170 years of unanimous agreement about the meaning of double jeopardy, only 46 years, which are an outlier in the arc of history, including American legal history, as the descendant of the common law. We have a clean slate with the 9th Amendment versus 14th Amendment argument. Creates a clear conflict. Mr. Bopp yesterday did not contest what the common law said. He was incorrect in saying that common law rights don't trump constitutional rights, because the 9th Amendment is a constitutional provision that de facto incorporates common law rights. As Professor McLeod said, the common law was the context for the Constitution, and it informs interpretation of the Constitution. He also, Mr. Bopp did not talk about Kennedy's 5-member majority opinion in Gonzales, and Justice Ginsburg's read of that opinion is saying that pre- and post-viability were not considerations and that it was allowing moral considerations to seep in. The committee also should not confuse a 14th Amendment oranges analysis with the 9th Amendment apples analysis. It's Liberty Counsel's position this is a constitutional amendment to the bill, and we would be pleased to assist in any defense that is offered for it.